Okay, it is 10 o'clock. We're going to call this meeting to order, certify that we do have a quorum, 4 members present, 1 absent.
Okay, it is 10 o'clock. We're going to call this
John
meeting to order,
Clement.
certify that we do have a
Quorum, 4
Item
members. 2 is opening
present,
prayer.
1
I don't think we have Reverend James Egan here. I will lead us in an opening prayer. Following that, Commissioner Snuggs, will you lead us in the pledges? Would everybody please rise? Let us pray. Dear Lord, we take a moment to pause this week to give thanks for the many blessings that we do have, Lord. It has been a tough year for many, but there's still many things that we can be thankful for this year, Lord. We ask that you watch over this court as we conduct the business of the county. May it be pleasing to your will, Lord. In Christ Jesus' name we pray. Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Honor the Texas flag. I pledge allegiance to thee, Texas, one state, under God, one and indivisible.
Thank you, Commissioner. Item 5 is public comments. I don't believe we had anybody sign up. Item 6 is the consent agenda. Does anybody have any items they wish to pull?
I make a motion we approve the consent agenda.
We have a motion by Commissioner Leon Clement, second by Commissioner Snuggs. All those in favor signify by saying aye.
Aye.
Any opposed? Ayes have it. Motion passes 4-0. Item number 7 is deliberate and consider possible approval of Treasurer's monthly report, which should be in your packet.
We don't know when it's going to stop. It may go all the way to the bluff. For those who aren't familiar with that, the river's moved several hundred, well, more than 300 or 400 yards in the last couple of years. Started in 15 with the flood, and then it's really magnified the last 3 years. And the road is closed basically because it's not there, but we still have the public trying to go down there. And you all know how it is. You can put road closed signs, dead end road signs, road washed out signs, concrete barricades, and the public will drive around them, steal them. Not the concrete barricades because they can't pull those off, but we need to close it. So I make a motion, we close that road.
We have a motion by Commissioner Leon Clement to close a portion of County Road 408. Second by Commissioner Snuggs. Any further discussion? If not, all those in favor signify by saying aye.
Aye.
Any opposed? Ayes have it. Motion passes 4-0. Item number 11 is open a public hearing requesting a special use permit by TYJ Realty for construction of a 60 by 100 commercial building for office/warehouse use at existing Willow Bend RV Park located at 11921 South I-35, Valley View, Texas, in Precinct 2. It is 10:04 and that public hearing is open. Do we have anybody that signed up for that public hearing? We have anybody that did not get a chance to sign up but wishes to speak? Hearing none. Item number 12 is to close that public hearing, and it is 10:04 and that public hearing is closed. Item number 13 is deliberate and consider the specific use permit request. I'm not going to read through all that one more time. So we do have the Johnsons here that made that request. It has gone through P&Z and was approved by the P&Z unanimously. This area is already zoned commercial. Y'all want to tell us what a little bit about it? You mind standing up so we can, at the microphone over here so we can hear you? It should be in the packet, the application, and it should be in the packet, the application, and it should be in the packet, the application, and it should be in the packet, the application. 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 It should be in the packet.
The rent house that we have there, and he services RVs all over the place now, and is in his own business, and he's trying to service them out in the backyard, but he wants the space also to serve, the RV. He takes care of all of our people, all of our tenants. So the new building would be 6,000 square feet, 3 spaces in it, and we're pretty sure that it would be Legendary Apparel expanding, so that Absolute Clean could be over in the old building, and then we would have Daniel servicing the RVs. Another great thing about, we're pushing it back so that it's not right on I-35, because there's a lot of water there. We don't want to redirect anything, so we're putting it back up on the hill. And then there'll also be a Columbia Spring for the RV park. Back there, commercial on the yeah, and the right of way, the I-35 might expand to there. We just don't want to stay out there, so we kind of push it up the hill. You go to the next page. I put the RV park in here because it's what you guys are all familiar with, but the red little box in the front is where it'll actually sit. And you go to the aerial, it's a better picture of where you can kind of see that it sits up the hill next to the other commercial building. Last page is just pictures of what it looks like along there, and then a rendering of what it's going to be like. So pretty easy, pretty simple, like uses, similar to what we have, just newer construction.
Good, I move to approve.
We have a motion by Commissioner Snuggs to approve the specific use permit. Second by Commissioner Leon Clement. Any further discussion? By Commissioner Snuggs. Not all those in favor signify by saying aye. Second by Commissioner Leon Clement. Any further discussion? By Commissioner Snuggs. Thank you guys. All those in favor signify. Item number 14 is to open a public hearing regarding the replat of lots 1594, 1595, and 1596 in Lake Kiowa subdivision in Precinct 2. It is 10:08 and that public hearing is open. Do we have anybody that signed up for that public hearing? Do we have anybody that did not get a chance to sign up but wishes to speak? Seeing none, it is 10:08 and that public hearing is closed, which is item 15. Item 16 is deliberate and consider possible approval of a replat of lots 1594, 1595, and 1596 in Lake Kiowa subdivision in Precinct 2. Commissioner Snuggs, you have anything on this?
Is this the Lake Lot one?
No, this is the, it's not the one he emailed us about the other day.
Okay, that's what I was getting confused on. No, POA signed off on it, so I'm good with it. I move we approve.
You have a motion by Commissioner Snuggs. I'll second that motion. Any further discussion? If not, all those in favor signify by saying aye.
Aye.
Any opposed? Ayes have it. Motion passes 4-0. Item number 17 is deliberate and consider possible action regarding resolution of intent to establish a PACE program and setting of a public hearing on the same. I believe we have some representatives here that want to give us a little briefing on that. And,
good morning, Judge Commissioners. Lee McCormick.
Give us a little briefing on that.
Hand out some handouts. Good morning, Judge Commissioners. Lee McCormick.
Give us a little briefing on that.
Hand out some handouts. Thank you. Good morning, Judge Commissioners. Lee McCormick.
Give us a little briefing on that.
Hand out some handouts. What's speaking?
Sure, go for it.
Thank you. Good morning, Judge Franklin, Commissioners, and thank you for the opportunity to be here. I'm Lee McCormick with Lone Star PACE out of Frisco, Texas. And I'd like to start off by just telling you a little bit about Lone Star PACE. We are a program administrator for property assessed clean energy programs here in Texas. Our principals have done program administration for local government since 2003. We've administered programs such as tax exempt private activity bonds, recovery zone facility bonds, new market tax credits, and property assessed clean energy. In the last 17 years, we've done over $22 billion of economic development and environmental programs in over 35 states. Here in Texas, we've done about $1.5 billion of economic development and environmental projects in over 40 cities and counties. But most importantly, Lone Star PACE is a registered municipal advisory firm. So we are regulated by the Municipal Securities Rulemaking Board, Securities and Exchange Commission, and the Texas State Securities Board. With regards to property assessed clean energy, we are here today for the first of two resolutions that the county would have to approve in order to create a property assessed clean energy program. So this is really just kind of an informational resolution that you're considering today. Property assessed clean energy, or PACE, is an economic development tool that assists commercial, industrial, and large multifamily property owners with either constructing or upgrading their buildings with energy and water efficiency improvements that are paid back over a long period of time in the form of a property tax assessment. Because PACE financing allows the property owners to finance for long term, they are able to then essentially align the utility bill savings from these energy and water efficiency improvements with the cost of the financing. And these types of improvements are nothing really interesting or sexy. It's your heating and cooling system, it's your LED lighting, it's your insulation, it could be solar panels, low flow bathroom fixtures. Really anything that saves energy or water can qualify for PACE financing. To date, 36 states have passed PACE legislation. In Texas, legislation was passed in 2013, but it wasn't really workable until 2015. And in the last 5 years, we've had roughly 50 cities and counties implement PACE programs to benefit their local communities. We are currently working on 2 projects here in Gainesville. And those property owners would like to utilize PACE financing for a portion of the financing for their renovations and or construction. PACE is a terrific economic development tool for the county. It helps create local contractor jobs, it helps upgrade older building stock, and it helps the county meet its sustainability goals without any risk, cost, liability, or administration on the county's part. All the fees are paid for by the property owners for the program, and our firm, Lone Star PACE, will hopefully have the opportunity to do the administration on behalf of Cooke County. I provided handouts for you to look at, but I'm not going to go over those in detail today. I think I've covered the majority of what's in those handouts in my discussion. Be happy to answer any questions now or stay around after the meeting if you'd like to meet one-on-one, and I'm always available either by phone or email if you have any questions later on. With that, I'd be happy to answer any questions.
And so just as a procedural clarification, so today, if we so choose, we can pass a resolution of intent to establish a PACE program, then we set a public hearing. Looks like in the statute it doesn't really say how far out that is, but let's assume we set it in December at the next meeting. And then we would have to take have that public hearing and then take final action at that time to establish the program.
So yeah, the statutes kind of lay out the process. There is an initial resolution required, which is here today, and then typically what most cities or counties have done has been at the second meeting, they would hold the public hearing and they would adopt the resolution establishing the program. In between, the county does have to post to the county website a copy of the program report, and that program report kind of is the very in-depth details of how the PACE program works within the county, what the county's parameters are for the PACE program. So it's typically two meeting process to get the program established. This is the first and the second meeting, assuming the county wants to move forward, would be the public hearing and resolution establishing the program.
The question I have, I know that there's a different type of lien filed with the appraisal district where it's on their taxes, on the property taxes.
So yes, so even though this is an assessment on it's a voluntary property tax assessment that the property owners are doing on their property only.
Right.
And even though it is filed in the public records for the county has no administration with regards to that assessment. The payments do not flow through the county tax assessor collector. It's a direct billing between the lender and the property owner. So there's no basically intermingling of cash that the county has to worry about. The only time the county really would get involved in certain cases, for tax reasons, those property owners might need a letter once a year from either the county judge or the tax assessor collector saying, here's what your assessment is for the next upcoming year, so that they can, from an accounting perspective, count it as a property tax assessment and get the tax deduction. But other than that, we do all the administration on behalf of the county with regards to promoting the program, overseeing projects as they come up to make sure they meet all the statutory requirements, and then on the back end administration, making sure those assessments are processed with the lender and the property owner efficiently.
I pulled up the law. Best, where they changed, 399, I believe it is.
Yeah, chapter 399, yes, sir.
And read through that several times. Now, do some counties manage this themselves, the loans? I call it a loan, you may call it something else.
No, it is, actually, it's a loan. It's
Yeah.
a loan secured by property tax. There's only no counties, every county that has adopted has used a third-party program administrator to do it. There's only one county that's even doing the processing the payments, and that's Travis County. They were the first county to establish the program. So their county tax assessor is receiving the payments from the property owners and then turning around and remitting payment to the lenders. The statutes allow for direct billing, so to speak, between the lenders and the property owners. And every other county that I'm aware of has basically said, we don't want to be involved
No,
in
we
that
wouldn't want to be
process.
involved in
Yeah,
that.
no, nobody else wants to be involved.
And we couldn't be
Nobody's-
forced into that at some time.
Yeah, no, there's no requirement at all with the county. That'll state in the program report. It'll basically state that this will not be any billing by the county.
I noticed in here, Cooke County will not at this time provide financing of any sort for the PACE program. So are there counties that are providing funding for this too?
No, under the statutes, the counties can essentially issue bonds, fund a pool of money and do these programs. Nobody has opted for that program. That was, when the legislation was put in place in 2013, some states were allowing it and some counties were allowing for municipal funded PACE programs. Even the states that had been doing those early on, all of those counties have essentially just mothballed their programs, because really the whole goal of PACE is to support energy and environmental sustainability without cost to the taxpayers. It's private dollars going into private projects, and that's really one of the great things about PACE is there is no taxpayer burden to help get these energy efficiency improvements.
That's what all the stuff says when we read the law. It's, it says in here, will not provide financing of any sort at this time. And I don't think any time. I don't want to tax. We don't want to become a bank.
What is the advantage over this program instead of just a normal, when you take the property as collateral, what's the advantage of doing the tax
That is
assessment?
a great question. The whole goal of PACE, the whole reason for property assessed clean energy is to incentivize these lenders to loan out for a longer period of time. So a normal commercial bank, if you go to your commercial bank and you say, I want to upgrade my heating and cooling system and I want to put in LED lighting and it's going to cost me $1 million for my building, they're going to give you a loan from 5, maybe 7 years. So for those first 7 years, you're going to be cash flow negative. You may be saving, $25,000 or $50,000 a year in your utility bills, but your cost of financing is $75,000. So you're negative $25,000 a year. What PACE does is it stretches out those payments for the useful life of the project. If the LED lighting and the HVAC system is going to last 20 years, those lenders will now loan out to 20 years. So your principal and interest payments each year are $50,000 or less, and you're saving $50,000. So from day one, you're either breaking even or saving money, which is a great incentive for these property owners to go ahead and do these upgrades, because essentially the utility will say, let's pay for the financing because you're able to finance it for a longer period of time. As a lender, if I have a security interest, it's just that HVAC system and that property owner goes bankrupt, I'm not going to pull the HVAC system out. It's basically, I've lost. It's secure as a property tax assessment. If that property owner goes bankrupt, that remaining balance stays on the property, like an ad valorem tax. So the next person that buys that property has to pick it up and pay. So as a lender, I know I'm going to get paid long term. So I'm willing to loan for a longer period of time at a lower interest rate.
But isn't it the same thing if they take the collateral and you put a lien on the property?
They can, but for equipment type of improvements, they typically, it's not, you don't typically get a lien on property.
And then maybe this could be piggybacked if they already have a lien on the property for the purchase of the property, and then this is assessed on where they have basically double. Okay.
So it's not government subsidized in any way. You're attacking the assessment, or you're guaranteed that it'll get tacked onto the property if it passes on or goes broke or whatever.
Correct. Yeah, it's not a government subsidy, it's private dollars, private projects, but you are giving that lender a better security interest than they would have otherwise. And that's why they'll loan out for a longer period of time.
And so this applies, does it apply only to upgrades on existing property, or does it apply to new construction as well?
You can do, that's a great question, because under the statute, there's some ambiguity, which I was going to bring up at the next meeting, but we can talk about it now. So the statutes say you cannot use PACE for an undeveloped lot. Now, there's one set of guidance that came out with the Keeping PACE in Texas Coalition that basically says, you know, if a lot, and we're not talking about a building, it's just the lot itself.
Yeah.
If the lot had any prior structure on it, even if that was torn down and a new building put up, that was a developed lot, so that qualifies. There's not a definition in the PACE statutes or any statute for an undeveloped lot. So some counties have taken different approaches. Some have used, under the water regs, there is a definition of undeveloped property, which includes lots, that essentially says if there's any water or sewer or drainage on that lot, that it was a developed lot. So therefore, it makes it easier to do new construction. Or you can go the way Harris County did, and they really went aggressive. They came back, which they're one of our clients, they said, we have a definition of development. And our definition matches up with FEMA's definition of development, which says if a property had had any paving, infill, grading, equipment storage on it at any point in the past, it's a developed lot, because they want to really encourage PACE. So they took a very generous definition of development. That's one question, probably one of the only questions we would come to you and say, here's some options for the county to consider. Where do you feel comfortable with, you know, as a developed lot definition? You can either use the Keeping PACE in Texas definition, says it has to have a building, even if it was torn down, that's a developed lot. You can use the water statute, which says it has water, sewer, or drainage, any of those three, it's a developed lot. Or you can go like Harris County and say we have a definition of development if you have one already for the county. If not, you know, the good news is, since it's not defined in the statute, it's whatever the county decides is the definition, is what the definition is, because it is the county's program.
So why do you need us to guarantee that it gets put onto the tax appraisal district?
Well, because only a city or county can put an assessment on the property tax record.
So we're basically putting the assessment.
Basically just filing a piece of paper saying this assessment is filed with the county. You're not guaranteeing anything. If the property owner goes bankrupt, again, the lender is at risk, but then they have very little risk because they now have that assessment on the property.
But the lending institution can't come back on the county or the municipality or the tax appraisal district in any way to...
No. The county has statutory protections as well, indemnification of the county. You as county officials and the county tax assessor collector and your staff have personal indemnification under the statute. We, in our set of documents that we've provided, the statutes give you personal indemnification. We actually, in our documents that the lenders and the property owners sign, have them also indemnify the county itself, which is not in the statutes. We think it's very important that the county have indemnification as well. I don't know why that was not put in the statute.
That isn't in the statute, is it?
Not the county. You as elected officials individually have it, but the county doesn't. So we basically have every party sign an agreement saying we are indemnifying and holding harmless the county as well for everything.
Mm-hmm. I personally think it's a good program to do, especially in light of, well, two real things. One is it's not costing the county anything. It's a way to have improved economic development, especially in a economic downturn like we're in now. And it's a way to make improvements on some of our existing infrastructure, existing buildings, and get them renewed or refreshed or whatever word you want to use, at no cost to the county. So I think it's definitely a good program to be involved in.
So the motion would be to pass a resolution to move it to public hearing?
So yeah, the motion would be to approve a resolution of intent to establish a program, and then set the date of the public
I make that
hearing.
motion.
And when do you set the public hearing? There's no statutory length.
Done is for both the program report and the public hearing notice, they have simply just had it on the agenda. There's nothing, you don't have to post anything in the newspaper or on the website separately. It's just They've utilized the agenda item for the public notice.
Well, just to cover our basis, what I'm probably going to do is, assuming this is your motion to put it on next court, which is the 14th,
It doesn't have to be next court, I would just,
well, I think that makes the most sense to me, but
That's fine.
unless you want to do something different. And just go ahead and do a public notice the same way we do any other public notices of public hearings and run it in the newspaper the week prior, and that way we cover that basis. We have a motion by Commissioner Snuggs. I'll second that motion.
I'd like to have some discussion
Go for it.
before we.
Yeah, a little bit more.
Yeah.
I think it sounds like a heck of a program, right until you ask the government to get involved. And I don't know why we would need to be in the financial business. And until we get to the resolution, you know, all the talk sounds good, but when it says Cooke County intends to make contractual assessments to repay PACE financing, why am I doing that? Why would I want to do that? That sounds like a commitment to go repay something. Am I missing something?
I agree with you completely, Commissioner, but it's almost kind of a pass-through type of thing. So because only a city or a county can put those assessment on the tax rolls, technically you are the ones filing that on their behalf of the lender. But there is no liability to the city or county, and probably makes sense if the county has an attorney, we usually have the county attorney look over everything, just to make sure you guys are comfortable that there's no, inadvertent commitment whatsoever. But I can assure you there is no commitment on the county with regards to the repayment of these loans.
And I get the verbal communication, but then when I pass a resolution and it's talking about contracts, then contracts are going to outweigh any verbal communication that we might have. And it says that we're at no risk, well, until this person doesn't pay. Somebody's at risk. And if we're the ones that signed up, sounds like we're working toward second liens and us basically being co-signers. And then as I move on down into, that was under bullet 3, and I hadn't begun to digest all this. Cooke County will contract with qualified organizations to be independent third-party authorized reps. And it talks about the county's administrative standards. We don't have any, so they're going to have to be written. We're going to have some type of administrative help, I would think, to follow up on this.
So that's what our firm is, Commissioner. Our
Okay,
firm is a
so-
third-party program administrator. So we do all of that. We have all the program documents, and our services agreement with the county covers all of the administrative activities that we were doing on behalf of the county. Assuming the county selects us as your administrator, which obviously is our hope.
Who's fronting this money to pay you guys to start with?
Comes out of our pocket. So there, as you're right, there's a lot of upfront starting costs for getting out there, marketing the program, getting out there and educating. Because part of what we do as a program administrator is we go out there and make sure that the property owners know this program is available. So we talk to the local contractors, we talk to the property owners. Now, it does help, obviously, that one of the reasons we're approaching Cooke County now is we have 2 projects that are interested in utilizing PACE. So that obviously helps us as a third-party administrator come in and say, let's get this program moving forward, because hopefully we'll get those projects across the finish line and we'll basically get compensated by the property owners when that happens.
But it's typically going to be a second lien, is it not?
So the way PACE works, the reason these lenders, has the same standing as an ad valorem tax. So it is a tax liability and tax rolls, and it actually takes priority over the first mortgage, but only for any past due payments. So if I'm a property owner and I've got $1 million PACE assessment out there and I'm past due $50,000 and I default, that $50,000 is in front of that first lien mortgage holder. And that's why under the statutes require that any time a PACE loan is made, that first lien mortgage holder has to give consent. It's called lender consent. So the first lien mortgage holder has to give consent, and if they don't give consent, the project doesn't get done. And the reason they're willing to give consent is I'm as a first lien mortgage holder, I just got $1 million worth of improvements put on my building that lender does not have a security interest in. So my building value went up $1 million. But if this property owner goes into a default, and there's $50,000 of past due assessment payment for the last year, if he goes into default, it's only that $50,000 that's in front of me on
$1 million investment
Right.
improvement.
So there's kind of a bit of a swap of assets.
So when you talk about ad valorem, then when they get ready to pay this mortgage, are they paying it back through the appraisal district to the county? How's it tied to ad valorem?
It's a direct bill to the lender, so the county doesn't have to be involved in any of the payment processing, and the statutes allow for that.
Okay. And they're gonna go make $1 million worth of improvements. Is that going to increase their appraised value, or are they actually gonna get a tax deduction for that?
Great question. It increases the appraised value. That's another benefit. We don't want to go and promise it's going to increase the appraised value, but yes, if somebody does $1 million worth of improvements, that ends up hitting the tax rolls, theoretically.
Again, I think the concern I have is why are we involved?
From what I understood, because I met with them prior, the simple part is we just have to allow them to use the tax assessment. We don't have anything to do with it. We just have to grant them permission for the appraisal district.
Until they start talking about these contractual things. You know,
Yeah.
like I said, that's, I'm hearing what people are saying, but I'm reading the document that we're talking about signing. And if we sign it as is, then we are going to enter into some contractual agreements, and we're going to take on some administrative responsibilities. And all that's going to, some of that's going to cost money at some point.
Right now, there's, I think, 54 cities and counties that have implemented PACE programs over the last 5 years. None of them that I'm aware of have had any out-of-pocket costs. Again, that's where yes, and that's part of the program report. And the reason we put the program is we actually have you approve the contracts themselves. So these are the contracts that are being used. You're comfortable with what's in there. And yes, in order to put that assessment on the tax roll, we have to enter into a contract with the property owner, and then we have to enter into a contract with the lender, and then we have to have, so the 3 contractors that are exhibits to the program report, which I don't know if you've seen that yet or not, but you have an owner contract, you have a lender contract, and you have a notice of contractual assessment. So the owner-lender contracts are with the 2 parties that are involved in the transaction. And then you have the notice of contractual assessment, which is what gets filed with the county, putting that assessment on the property tax records. And yeah, you read through the owner and lender contracts, which I don't know if I provided those to you yet, Judge, or not. Okay, I may not have, may have just given you the first. But you will have those. If you don't have them now, you have them here the next day with the full program report. But you'll have, when you read through that, if you have any questions, Commissioner, I'd be happy to get on the phone.
Well, I know you've tried to visit with me, but I wanted to wait till we brought it before the court, you know, and actually disclose some of this through the media and stuff of that nature, because if we're going to have a public hearing, then I'd like to see some people be involved in it that probably understand it much better than I do.
Sure.
And now, the motion on the floor, is it to have the public meeting, or is it to approve this first resolution?
It's to do both. So you approve the resolution of intent and then set it for a public hearing. I guess to answer or to ask the question I think you're getting at, what if we approve this and then don't approve it at the final, at the hearing? Does this?
I'd like to give us a little more time than just a couple of weeks, because I'm still a little bit concerned. Laws are kind of funny things. You know how many laws have been passed in the state of Texas, and those resolutions we vote on, and they say, well, is was in the other place. If is would have been moved forward over in the sentence, then that thing that you all passed and voted for would have meant something different. But it doesn't mean that, because we moved one word over. And I read it and reread it, and I'm not an attorney. I read it and reread it multiple times last night, and it says the county is going to be the one doing, I call it the billing, the paperwork. You'll be doing the financing, and we're going to be on the hook for managing this thing. Now, what does Doug Smithson think about this?
I've shared it with him, and that was pre-COVID.
Yeah, you know, he ought to be sitting in here with this, since the tax appraisal district is going to be involved. It's not that I don't trust you. It's just that I've heard too many good stories before, and I made a mistake by not looking at the fine print close enough.
Sure. I'm happy to answer any questions you have, Commissioner. If you want, I can look at the statutes and give you the section that talks about the direct billing.
I want to let the county attorney or somebody look at that. That was one of the reasons I didn't meet with y'all either. This is I read the information you sent out first, and I thought, no, we ought to have a public discussion about this instead of having all my questions answered over the phone or through emails, and it ought to be talked about here. It may be the greatest thing in the world. I just want to make sure 10 years from now, somebody doesn't look at me and say, why did you ever agree to that? Now you're managing loans and you're taking second liens on property. Because the initial read, that almost sounds like what it is. And, you know, when it says at this time, we won't be providing any financing, I don't want it to say at this time. I want it to say we will not be providing any financing. At this time means somebody's going to come in here, maybe, and
Is that in the statute, or was that?
it's in this.
Is that a staff report?
Where did it go?
You're looking at the resolution?
Yeah, I'm looking at the
Oh, the
resolution.
resolution, okay.
Yeah, Cooke County will not at this time provide financing of any sort for the PACE
I
program.
believe, Judge, if you correct me if I'm wrong, you could actually at this point make a motion to amend that resolution to that effect, and that would be perfectly fine with us.
And strike the word at this time and just
Yes.
say Cooke County will not be
Yeah.
Will
providing.
not provide
You
financing.
can approve
of any sort.
subject to striking that language.
And Lee, define assessment, if you will, as used in this resolution. I'm assuming you've seen the resolution, right?
Yes.
Okay, would you define, I mean, is assessment, are we putting a price on something, are we leaning something? Would you share with me?
So the assessment is really nothing more than just a document that's memorializing the lien on the property. It's really just a lien document.
It's a lien document,
Basically,
okay.
it just memorializes the fact that there is a lien, and that assessment itself will have a payment schedule that matches up with the loan schedule. So if it's $50,000 a year principal and interest on the loan, then the assessment will have a schedule that says $50,000 a year is what the assessment is. So it really, you can almost look at it like a loan document, or at least the payment schedule on the loan document, and that gets filed with the county saying, here's the lien on the property, here's what this property owner owes ABC lender that's secured, and has the same standing as an ad valorem tax. And really, the only time the county would ever get involved is in the event of default. If that property owner defaults, then the statutes say this goes through the same process as the county. I don't know if you guys use a third-party collection agent. So yeah, if the property owner defaults, then we as the program administrator would notify the county, but then we would also notify your collection agent.
Yeah.
We would work with them. They work on a contingent with the county. They work on a contingent on this as well. So again, the county wouldn't be any pocket. There's really no administration. You would just get a notice. When the property owner defaulted, we as the administrator are going to go ahead and work with the county collection agent to go ahead and basically go through the same collection process as if it was an ad valorem tax.
But at some point, the first lender, or first lien holder is going to be in that loop, I would think.
Right, they would. Usually, I'll be honest with you, what typically happens is if that property owner is past due on $50,000, they're probably past due on the mortgage. So with that mortgage lender, just like anytime, they're gonna go ahead and pay that $50,000 so they control that foreclosure process. I'll be honest with you, I've never known of a county anywhere in the country that's had to go through the foreclosure process on a commercial PACE loan.
And so I go back to bullet number 3, and the county intends to make a contractual lien contract to repay PACE, which would be you guys.
We do it on behalf
So,
of the county.
and I'm not trying to play a word game, I just truly want to understand what I'm reading. And again, this motion is to,
This motion, I guess as made, was to approve the
I didn't hear the word resolution in that motion.
resolution of intent to establish a PACE program and setting up a public hearing for, right now, it's December 7th, or December 14th. We can change that
I'd
to,
like to change the date back just to get a,
we can move the date and strike that at this time language. In my understanding is at that meeting, there'll be a secondary resolution that'll go into more specifics than as far as how to administer the actual program.
Right, you'll have the program report.
Yeah, at that time and not,
I would personally like to see you separate the public hearing and the resolution.
and I don't know statutorily if that's possible.
I think you can, Judge, if you like, you can separate it. I don't know if you want to do the public hearing at the next meeting and then the
We can-
resolution after that. So you get public
Because,
input.
I mean, I can tell you straight up, the resolution, the way it reads today, I'm not going to support. So I will support the public hearing to hear from the public we would like, but, but my biggest concern is why is the government involved? My second is, this resolution talks about contractual agreements, and I want to be real careful that I'm not party to signing some folks up for, or the county being the second lien holder, basically, or committed to lien somebody so I can pay Pace.
Using the tax appraisal district as the hammer to do it, basically. How many counties do you say have counties different?
Currently, there's, I think, total of 54 cities and counties. Collin County, Denton County's got a program. We've done a project for Denton County. Collin County passed their, a resolution in October to move forward. It wasn't the official resolution intent. They passed a resolution in October, or an order in October to get a resolution on the agenda to move forward. Dallas County passed their intent resolution in the end of October. So we expect to have Dallas County's program running by year end. So
When did the state pass this?
the legislation was really passed in 2013.
2013.
It wasn't until 2015, though. They had some cleanup legislation that went in that it really became, that's where the liability protections came in 2015, and then the counties got.
Most everything I found was 2015 on.
Yeah.
You
So
got
it's
some
only been
smaller
around for about
counties?
5 years.
I'm sorry, do you have some counties with smaller population that you're working with or that has passed the program?
Sure. Smaller counties, Hayes County is a client. So we've got Hayes County, Jefferson County, Galveston County, Freestone County is a small county that's got a program. City of Burleson's got it on their agenda for their final resolution. I think Prosper, actually, City of Prosper has their own program.
I was looking for something population-wise, something equivalent to what we have, because, you take City of Burleson or City of Prosper, they all got populations. The city has larger populations than our entire county.
Yeah.
So I was kind of looking for something, apples to apples.
You have the full spectrum of county sizes that have adopted programs. I mean, from very small rural counties down on the border to Harris County is our client. They're obviously the biggest county in the state, so.
Look statistically, if there's 254 counties, now that 254 counties, basically we have 50 counties and cities that's gone with the program. Numbers-wise, that's 20% of the people, or 20%, well, that's not even 20% of the counties or the.
Right,
If you
but
take,
it's only been around for 5 years.
Yeah.
As you can see, this process is not a quick process. It's typically, even if you have a county that's interested, I'll be honest with you, it's about a 3-month process per county. And so it's just, we have not had any issues with any counties. I can tell you, judges and commissioners, there's been no issues with counties. It's just a matter of, we don't typically approach a county unless we have a project there. So it's, at any given time, we probably have 5 or 6 counties that we're working on getting approvals on because we have priority rights, but we don't, because those counties become our clients. And if you are a county that's my client, I now have to go out and do contractor training and do, lender training and do education. So we have very intentionally grown at a measured pace to make sure we're approaching county-wide projects, because once you're a client, you're going to be out here spending time and money basically building a program on your behalf, but we don't want to just go out and have a ton of counties that we can't service.
it sounds like it ought to be a good program. Like I said, I'd like to see less government in my business than more, but,
I agree, Commissioner. It is kind of odd with the way, it's not a difficult program, but PACE is a different program because you have, government really just stepping in and just, almost essentially just filing one document on behalf of the lender. Just put that in there. But to do that, to have the authorization, you obviously have to have a contract with that lender and a contract with the property owner so that everybody understands what everybody's role is. But when you see the program report, I think you'll have an opportunity to read through it. Hopefully you'll feel comfortable after looking at it.
And that's the last concern I have still is the tax appraisal district. Doug Smithson's the chief appraiser. He ought to be involved in a meeting since they're going to be
Involved in the process.
integral part of the process.
Yeah, actually,
That he needs to be involved. I don't want any surprises.
sure.
I don't want somebody telling me why did the county dump this on us, which I don't know if he would or not, but I don't want him getting too surprised.
I guess I just assumed that he would be in the loop through them. I should have asked that question.
And again, his involvement should be, do you have to file in the official records for the county, do you file through the tax assessor collector, or you file with the clerk? I know most counties we file with the clerk.
We file with the clerk.
Yeah, so he literally would not have to be involved, because he's not part of the payment process. Payments won't come to him. The only time he would be involved is if the property owner wanted that letter we talked about, that once a year letter, that can either come from the tax assessor collector or the county judge. Basically.
So,
They're in the process, if there's a default, who's involved in that? The tax appraisal district's not involved?
so the appraisal district does our tax collection as well.
Okay, then they would be involved.
Then they're involved.
Do they use a third-party collection attorney, like in Prairie, do you know?
They push it back to the entities that use so each entity has their own collection attorney for collecting delinquent taxes.
Okay.
If it's going to come out on your tax statement, what it is, the tax appraisal district is involved. And we'll get it all figured out, but we need to have a few weeks to make sure everybody knows. Because when they open up that stub, if it's the school tax or the hospital tax, they all think it's the county tax.
Sure.
And, since it's not going to have our name on it, I want to make sure we're all on the same page.
Well, if they're gonna do $1 million worth of improvements, it's not gonna be obvious. So somehow we're gonna, if it's water and electricity, just to look at the perimeter of the building, measure square footage like the appraisal district's typically gonna do, somehow we need to communicate those improvements so somewhere in there you're gonna have the appraisal district involved.
Well, you'll get an annual report. What we do is we come to the county once a year and give you an annual report of our projects statewide that will obviously talk more in depth on the projects that we've done in Cooke County.
So revise your motion.
Yeah.
So are we,
Withdraw my motion and start over? Or how do we do that? This is first.
It's not a first, we had to withdraw.
We've had plenty of withdrawals. Yeah, you've had to withdraw, yeah, we have actually.
We just forgot it.
Because I wasn't dead set on it being in 2 weeks or
It
anything.
doesn't have to be, I was just,
Let's withdraw your motion, we'll start all
I
over.
know how slow government can be sometimes.
Yeah, I understand.
Sometimes it needs to be.
I'd like to withdraw my motion.
So if we can approve the intent, resolution of intent and set a public hearing, or we can set a public hearing and then consider it again at that point. Whatever you guys.
Harry, you had heartburn for doing both at once?
Well, my thought process is if we have a public hearing, there's some negative feedback, then I certainly don't need to move forward with the rest.
Yeah. Well, the line, to be honest, Commissioner Hallwell, that line you have issue with is the line in statute that says it has to have.
Well, court can pursue it any way they want to.
I couldn't hear you.
I don't, I guess, repeat that.
The line that it says, I think that line number
I'll start
3.
off in bullet number 3.
In bullet number 3, Cook County intends to make a contractual assessment to repay PACE financing, and that particular line is in 399.0081C, B, a statement that the local government intends to make contractual assessment to repay financing for. So, it's almost verbatim.
So that's a dictation,
That's a dictation.
okay? That's all I need to know.
And I understand your fear. It says agreements to repay PACE financing, but we're just doing the assessments or allowing the assessments.
Well, without you, there can be no second lien.
100%. Yeah, no, I
This
totally
program.
Not under
understand.
that program. Yeah.
I'm sorry?
Not under that program, yeah.
Yeah, not on that program.
So we're involved.
Mm-hmm.
Yeah.
Well, whether we contract that out, and that's what most counties apparently do.
Well, and if you were gonna do it, you'd want a third party.
Yeah, and that's the one that makes the most sense.
But I think it'd be a great program if we wasn't needing to endorse it. And then when we talk about indemnifying somebody, you wouldn't have a need for that coverage or clause if there wasn't a risk.
Yeah.
Anyway,
Thoughts, gentlemen?
You want to clear this up and then bring the whole thing back?
We could do that. But, or we set it for a public hearing that kind of lets the public more involved in that process.
have a public hearing?
Yeah. And then we can
And then.
Digest it between
and then
now and then.
digest it between now and then.
bring Doug and,
I'll certainly give it more consideration. I mean,
so do we want to have the public hearing 14th too soon? And then the next one would be the 28th. which is-
Yeah. They'll give us, hell, we're going through the holidays and everything, you know,
Give it to the 28th.
I'm not gonna find anybody to talk to. Everybody will be off.
maybe I'm making too big a deal of it. Maybe I get some feedback meantime, but you know me well enough to know where I'm at this moment.
Well, anytime you're committing the county, that's not just us. I appreciate I appreciate the comments about we'll be held harmless and all this. This may sound a little goofy, but I take care of myself fairly decently. The county, that's a whole nother gorilla that I have to tend with. And trust me, I'll beat myself up enough, but when I've got everybody in this county upset that, why did you do this? I don't take these things lightly because,
No, absolutely. We want to make sure that everybody up there is comfortable with this program before moving forward. So we'll do whatever we need to make sure all your questions are answered and any questions from the public are answered ahead of time.
I'll make the motion, we set the PACE program just on the establishment, not the resolution, on the establishment for a public hearing on the 28th of December.
Second.
Second by Commissioner Hollowell. Any further discussion? If not, all those in favor signify by saying aye. Aye. Any opposed? Ayes have it, motion passes 4-0. Thank you, gentlemen.
Thank you. Have a great Thanksgiving,
Thank you.
everybody.
thank you.
I'll wait till the,
That's a different sounding one, isn't it?
it's because coming off the buildings or something. Item number 18 is deliberate and consider possible action regarding payment of certain EMS and paramedics for earned vacation, holiday, and personal time that will not carry over from EMS line 001540-119. Elizabeth, I saw you sitting back there. You want to come tell us what the,
They're not able to take their time off.
I've not heard myself speak on this, but I will.
oh, I thought you, well, Kevin's not here, so he would.
In Kevin's absence, he has some employees that have time that will be over the limit at the end of the year, and they will not be able to use it or all of it due to shortages on shifts and several overtime hours they're already working. So on his behalf, I've requested this to be paid out to them. Whatever it is, they weren't able to use, it's over the limit.
You get any idea how much money you lose?
It's, total is, looks to be 14,740.
14,700, yeah.
This is COVID driven.
Almost,
He's
yeah, I mean, if you can't take vacation,
Yeah, he's got a lot of
because,
staff that's been out.
and I think if, the other option would be to roll it forward.
That's correct, that would be the other option.
But my concern with rolling it forward is we don't know how much longer we're gonna be in this, and then are you gonna have everybody off at the end of, second half of next year?
They'll compound it next year.
I mean, I wish we could say, hey, let's roll it forward, because I think some of them would probably rather have the time, but I don't think that that's a viable option either. It's the same issue we get in on elections.
Right.
I think you,
Do you have any idea of the number of people this involved? 10, 15,
Probably 10
25?
to 15, yeah. I don't have the list with me.
I think you pay it, and then because it's COVID driven, can we do anything through CARES?
We can do, since it's still between now and the end of the year, we can probably, I don't know if we can do anything through CARES.
I heard you.
Concern is because
But I don't know that I can claim it because they didn't work.
because they're already paying them for their overtime and stuff now, right?
Right, but I have to turn in hours worked, and this isn't hours worked.
It would be double dipping, I guess, if we tried to come back now and charge it to CARES, because they're already paying toward those salaries now.
Yeah.
Well, but this is a benefit we're paying. I mean, it's not,
But it's driven, some of the overtime has been driven because of the COVID,
Yeah.
which has not allowed them to take their time. I'm not trying to talk us into jail, that wouldn't be a pleasant.
no, I understand.
I'm just, something to consider.
But I don't think I can claim
Motion, We
it.
pay it.
We have a motion by Commissioner Hollowell, second by Commissioner Leon Clement. Just a little bit more on that, Shelley. I mean, in a roundabout way, we are getting some reimbursement from that if we're using some of the CARES Act funding to pay salaries anyway.
Yes.
So, I mean, there is benefit coming to that net, that bigger picture.
Overall, yes, in the bigger picture, yes.
Yeah, that helps cushion the blow of $14,000. We have a motion and a second. Any further discussion? If not, all those in favor signify by saying aye. Aye. Any opposed? Ayes have it, motion passes 4-0. Item number 19 is deliberate and consider possible approval of newly hired clerk for county clerk's office, commencing employment for the election training purposes prior to the current clerk's departure. Pam?
So what this is my Chief Deputy Amber has put in her resignation, and her last day is going to be December the 11th. So what I'm asking is for my new clerk to start the week of December the 7th. Since I'm going to be in the middle of early voting starting at Wednesday, I would like for this clerk to be able to start, so she has to take a security awareness training to be able to work the elections and to be able to work in our election system, which takes about 2 days to a day and a half, depending on how busy they get, or hopefully she maybe could get it done in a day and a half. And then also Michelle, that same week, has to do vital statistics conference for 3 days. So I was hoping Amber, since she'll still be here that week, could train the new clerk in the election system. That way she can help out that next week with elections. I'll be still in the middle of elections, and then election day on Saturday she'll have to work, and it'd be nice if she could work in the election system.
I'd move to approve, but the question is, do we need to move money with it?
We have a motion by Commissioner Hollowell.
But do I need to add to move money with that
I'll
motion?
second that motion. I don't think so yet.
Shelley?
There's probably funds in that line item, but we'll probably have to move it in before the end of the year.
Elections, that's what, I was going to have to get with Shelley on that and see.
But I don't know if that's,
Yeah, that's what I was asking. I didn't know if that's something.
She wanted to take it out of election expense.
Can you do it legally?
No?
no.
Okay, I didn't know what we could take it out of.
We need to find the money, make it happen.
But, well, there's nothing on this line to move money.
Oh, because the way it's written on the agenda, okay.
Yeah.
Make the motion that,
We do have the motion. I seconded it. Any further discussion? If not, all those in favor signify by saying aye. Aye. Any opposed? Ayes have it, motion passes 4-0.
but we will find the money.
Yeah. Item number 20 is deliberate and consider possible approval of newly hired nurse for the jail commencing employment for training prior to the current nurse's departure. This sounds familiar.
Did they get together or something?
We already budget for a half a nurse.
We already have money in there for half a nurse?
How do you get a half a nurse?
Well, that's a technical issue. You would, sounds like a medical procedure.
Basically, what it is that the current nurse has been giving a letter from the oncoming sheriff that her services will no longer be needed. We have found a lady to take her place. She is what they call a master RN. She's not LVN. We have a salary that we can pay half of it, the other half will come from a vacant jailer's position until January 1st, and she will move into the nurse's salary.
So you have the money, you just need the approval?
Yes, I just need permission to have 2 nurses instead of 1.
So, is everybody going to be satisfied with this nurse?
I'm sorry?
Is everyone going to be satisfied with this nurse?
I think so. No, he has agreed. Ray has agreed that this,
Okay,
yes.
He's been part of the selection
Oh,
process.
yes, yes.
okay. All right.
We had a motion by Commissioner Snuggs,
Second.
seconded by Commissioner Leon Clement. Any further discussion? If not, all those in favor signify by saying aye.
Aye.
Any opposed? Ayes have it, motion passes 4-0.
Thank you.
Thank you, Terry. Item number 21 is deliberate and consider possible approval of interlocal agreement with Regional Public Defender Office for capital cases. We first started this last year, and the contract is in the packet.
We have to sign a new one every year?
My understanding is yes. Unfortunately. But I could be wrong.
And ours is $21,238 a year.
Yep. We have a motion by Commissioner Hollowell, seconded by Commissioner Leon Clement. Any further discussion? If not, all those in favor signify by saying aye. Aye. Any opposed? Ayes have it, motion passes 4-0. Item number 22 is deliberate and consider possible action regarding courthouse annex remodel. On the downstairs, I know, Rick, the carpet's been installed, and the interior lock that was also needing to be done has been done. So I think the downstairs courtroom part of that is done. I don't have anything else on the upstairs. I think I got an email from Komatsu saying they couldn't find any additional payments, or any, not payments, but any additional documentation, I think was what that email said.
It took him quite a while to say it, but that's what he meant.
Yeah, that's, he summed it up nicely in 2 paragraphs.
Or 3.
Yeah.
Or what.
But I don't know if Shelley, if you were able to find anything else on any, that were going back that far.
No, what I sent Charles, what I could find.
Apparently, they didn't do the assessment before the purchase is what.
Yeah.
I didn't find one.
So I don't have,
Unless it was done by somebody other than
unless,
Watson.
yeah,
But it wasn't charged to
that project,
that project.
okay. So I don't have anything new other than that updated information, unless anybody else does on the annex. Hearing none, 22 would be no action. 23 is deliberate and consider possible approval regarding action for radio purchases for Homeland Security grant through TCOG. We get obviously some money through the Homeland Security grant every year. This year, I think our money is, if Ray is sitting somewhere over there, I think we got roughly $10,000 coming.
We have approximately $27,000 total, about 15,000 to 16,000 that was spent on EMS tactical vests and helmets. And the remaining approximately $10,000 was earmarked for mobile radios for the commissioners' precincts. But in lieu of recent events, just wanted to make sure what we wanted to do with that money. It needs to be spent on communications in that area. We pretty well have that pre-approved.
Thoughts?
My position hadn't changed. If we think we're going to upgrade our radio communications, we need to go, I would think, buy a couple of 100-watt radios with it.
And how much, do you know the exact number, how much money we have?
That's approximately $10,000.
Okay.
10,000? I can barely hear you. Yes, sir, $10,000. Okay.
So a couple of, if we increase our radio communications infrastructure, we're going to need, it does make sense to buy something that is going to be compatible with the upgrades as opposed to spending $10,000 on something that's not going to be potentially compatible in a matter of months or so.
Amazing.
And I think we got a pretty short fuse on this, don't we? We've got to act.
Yes, sir.
Ideally today.
I'm fine with it. Buying a couple of 100-watt radios, that'll pretty much soak it up, wouldn't it?
Yeah, probably. Gary, you got any pricing on that? Can you get with Ray on that?
I need a specific model and
Yeah,
that information.
all that.
I think it would be a great idea for Commissioner Hollowell to get with.
It's really pretty simple. I can, because this was not part of the.
Wasn't part of, yeah.
This, I'll forward you the quotes. Guys, these things they're not cheap, but when we go to a decent system, these will be 700 compatible.
And I'd also rather spend money on, I'd rather spend not cheap money on something we're going to be able to use than cheap money on something we're not going to be able to use, if that may be the crudest way to put it.
These are buy board prices, and the radios and antennas, or antenna with VHF's about $42.95. So, and, but then you can turn on the 700.
If and when we go to that.
Yeah, and of course, when you go to 700 with dual band radios, you will have 2 antennas. So, but anything and with the wattage is gonna be expensive, so.
You need a motion?
Need a motion to utilize those funds to purchase,
These are Motorola APX 8500.
there.
Second.
We got a motion by Commissioner Hall, second by Commissioner Leon Clement.
Sounded like he made one to me.
Any further discussion? If not, all those in favor signify by saying aye.
Aye.
Any opposed? Ayes have it, motion passes 4-0. Item number 24 is discussion regarding, and consideration regarding various grants. 2015 FEMA is the first one.
I've received 2 emails. They're working on what we submitted prior. They wanted canceled checks front and back of invoices, so I sent those.
From when? How long ago was that?
2 years ago.
2 years. Amazing.
Yeah.
One was for precinct 3 and one was for precinct 4. The one for precinct 3, they had the top sheet, which was the summary sheet, but they claimed that they had no documents behind the summary sheet.
Did we just get a new set of people again with Conan Resnick?
Yes,
Is that the 5th set or?
I stopped counting. So I resent them the email that I originally sent, or, uploaded, and I said, if you have the summary sheet, you should have had all of the things behind it, but somehow or another, they sent me a whole stack of invoices to get canceled checks, so I don't know how they didn't have the summary sheets. I mean, the meat of the, behind the summary sheet.
These are the same people that made fun of Ernst & Young for not keeping up with the paperwork, right? Yeah.
And then on your project worksheet, they just needed the canceled checks. So we got those and sent them off. And I haven't heard anything else. But I mean, they were invoices back to 2015, so up to current.
So no new money, though.
No money.
If we get
But
this
we've got-
money,
It'd be old money. Yeah.
But we have movement,
we have movement.
yes.
So no action on 2015 FEMA. B is FEMA 2020 COVID-19. I don't necessarily have anything, but I know with the CARES Act money ending next month, there is that FEMA declaration still out there, and any future expenses after that, we could probably look at that 75-25 split that we usually have on a FEMA-style project.
How's it going with the schools?
That's the next one down.
How's it going with what?
With the schools, they're all intertwined.
Which is item C, CARES Act funding. We've gotten both the MOUs and the supporting documentation from, I don't have that list in front of me, 4 or 5 schools. And so we got an MOU from Walnut Bend right here. They said supporting documentation should be coming shortly.
We've gotten Munster, Callisburg, Gainesville, Lindsay,
Valley View.
and Valley View.
Yeah.
Nothing wrong with being on that one.
And Walnut Bend has their MOU, but they said they'll send the documentation. And I've sent out reminders to.
And Civil, did I say Civil's been?
I don't
and
think
Civil's
so.
been.
And, yeah, they're slowly trickling in.
Take out, sorry.
When's the due date on that?
Whenever the end of,
Well, I have to submit everything by December 15th.
yeah,
Oh, wow.
so two
But they
weeks,
they had to have purchased everything before October 1st.
which most of them did.
Yeah. Before school started.
I'll send another reminder email this week, but most of them they're slowly trickling in. We do need to approve the MOU with Walnut Bend. Do we have a motion?
I'll make that motion.
I was looking to the commissioner whose precinct that was in, but that's fine.
Fine.
I have a motion by Commissioner Jason Snuggs.
Wait a minute, what? This motion, is it to just Walnut Bend, or?
Yeah, just to approve the MOU with them.
I thought you said we need it.
No, we've got it on the agenda for today.
Oh, okay. I'm
Yeah.
sorry. I thought
That's-
I would make the motion. Don't be stepping in my turf.
We've got a motion, let me stress that, we got a motion by Commissioner Hollowell, seconded by Commissioner Leon Clement.
Wow.
Oh, too much fun. Any further discussion on that particular MOU? If not, all those in favor signify by saying aye. Any opposed? Ayes have it, motion passes 4-0.
I was about to text the superintendent.
No, we've got the,
Misunderstood you.
he said he would get the documentation sent to us too, so I've been in communication with him last
I was
week.
multitasking.
I understand, that gets everybody in trouble
Hard for an
sometimes.
old man to do that. Jim.
You're over there dealing with your road crew like I was.
Item D is the public safety COVID grants. I don't have anything new on this unless Shelley does.
Now I've got the, October paper-ready report, clarified some things with the jail. I need to clean it up a little bit and submit it. Other than like $5.35, I think we're gonna take care of that grant.
Good.
Out of curiosity, are we broadcasting or not
We're
broadcasting?
broadcasting. I think that tablet just went dead though. I'm assuming we're still broadcasting, yeah.
I don't think it's been on the entire meeting.
It's went off early in the meeting. Item E is CTIF road grants.
I've got all the invoices pulled for it, so all I gotta do is fill out the request for reimbursement page and get that sent off.
Anything further on CTIF? Item F is elections grants.
We got an email on Friday that they have extended the submission deadline from the end of November to the end of December, but all of our money has been spent. I have all of the copies of the invoices and checks. If they would just open it, I could submit it and be done with that one, but every time I try and go in, it's not open, so that one is finished also.
All right, 25 is executive session in compliance with Texas Open Meetings Act 551 of the Government Code. We have personnel matters, consult with attorney, and deliberation regarding security devices and audits. It is 11:12, and we'll take a short recess into executive. All right, it is 12:07. We are back in regular session. Item number 26 is deliberate and consider possible action on public health emergency for COVID-19. Ray, do you want to give us just a little bit of a briefing on kind of a snapshot of where we're at?
Yes, sir.
We continue to report the numbers on through the Facebook page particularly. That's going to be the day prior's number the next morning, and so Friday's numbers hit Saturday morning, and Monday's numbers hit Tuesday morning, and the rest of the days of the week, so on. As of Friday, we reported 271 active cases with 1,230 total cases since we started reporting with 12 fatalities. That number includes last Tuesday's mass testing or mobile testing. Those numbers do not include Wednesday or Thursday last week, and we've still got testing today and tomorrow, drive-up testing out at the Fair Association barn. I also provided you with a couple of brief snapshots of our current situation. We are part of the Trauma Service Area E, or ECHO region, and so that's part of the whole discussion when it comes to the 15% hospital occupancy is by your Trauma Service Area region, so we kind of track it that way. And that includes most of the Metroplex and surrounding counties of Dallas-Fort Worth. The one document shows just a 2-week snapshot of trends for admissions and patients in the hospital. Current admissions daily appears to be not dramatically increasing, but increasing slowly. But overall, hospital admissions has been consistently increasing pretty rapidly for the last month and continues on that same pace. And that's in the diagram with the 3 lines running horizontally, the top line being the current in-hospital patients. And the next one just discusses all the counties in the trauma service area and their hospital reporting, as well as their capacities and at least on that particular date at that particular time, what their occupancy was. That number changes. I believe those are due by noon every day, and so again, that number can change pretty significantly throughout the day, but it's a snapshot. Hospitalizations in general, we do talk to our hospital every day, both of them, and get their information, what's going on. Hospitalizations have increased dramatically even in our area, at our hospital. Getting information from other counties, other hospitals, and providers trying to place people at hospitals. Almost everybody is getting to or near capacity. Being able to transfer patients used to be a very simple task here to send them to another bigger, larger hospital with more capability and more specialists on hand. That is getting very difficult to do. Almost all hospitals now, if you take a patient, they're pretty much going to be your patient. And so the ability to move them around or send them somewhere else is very difficult right now. And that goes to the whole point of, we know we're not going to stop this, but our goal is to slow it down enough that our medical system can take care of it and handle it. And so when you need to go to the hospital for whatever that emergency is, even if it's not COVID, if it's full, it's full. So our goal for everyone is to try to slow it down, take some responsible actions to not be part of the spread. The last diagram is that TSAE, Trauma Service Area counties outlined and highlighted by their percentage of COVID hospitalizations. Again, as of Sunday. And in Cooke County, it was almost 30%.
What's that in numbers, Ray?
Sir?
What is that in numbers?
That would be back to the previous.
It's 11 out of 25, I think.
And that's
Available staff versus Census confirmed.
Right, that's, you see GA 32,
That's that percentage.
percent of hospital capacity with lab confirmed COVID.
And just as a general issue, and it's not just happening here in Cooke County, but all across North Texas and all across many parts of the United States, the issue may not necessarily be the number of potential beds, it's the number, it's staffing issues, it's number of available staff to actually serve those patients. If you guys look at that number on the second one, that the bottom line, the 14%, 14.41%, just as a somewhat cautionary tale, if that tops 15% as for the region for more than 7 days, per the governor's GA 32 order, there is some rollback of his opening that would occur.
Even though he's suggesting to the media there won't be any more shutdowns.
Well, yeah, this is over a previous order, but I'm just saying, I'm just the messenger, but that's the, it has to top 15% for 7 days or more. And at that point, restaurants would roll back to 50% and bars would close.
But he did say
no new ones, I think, or no more, or no further, but that's that's why that number's there to track, because that is a current, criteria.
I do believe it is important for the public to understand that when we say the hospitals are full means what? Full means we don't have enough trained personnel to take care of the people, not that the hospital doesn't have an empty room. There is a difference between the two.
Yes, sir. Any,
How long, let's say you go over the 15%, I understand for 7 days, so then you go over 15% for 7 days, then how do you get back off of that?
I think it's got to be below 15% for 7 days.
7 days, it's the same time
I think it
period,
is the
isn't
same time period. So you're not seesawing back and forth
Yeah.
every day or
Yeah.
something. But we're not the only region that's watching that number, and that has slowly climbed over the past month. So it could become a factor in the near future. Any other questions on thoughts, comments? Ray, you got anything else?
No, sir, just that reminder that we do have the testing available all day, 9 to 4 today, 9 to 4 tomorrow at the Fair Association Barn on Justice Center Boulevard. It's best if you can sign up online, but if you don't, you can still show up and they will sign you up when you get there. That testing, contrary to popular belief, does not create more cases. It identifies the cases that are already here. So they're not making any new ones, but we're at least able to identify them and provide them the information that can help them slow the spread.
And any cases that are reported locally are local people. So if somebody from out of county tests there, they're not reported as a local case.
That's correct. We do, and it actually was a really small number, at least on the data we have from Tuesday last week. There were only a few out-of-county residents tested at our site, but that information for their test, it goes to their county of record or residence.
All righty. Last thing for anybody that's listening or watching, just with the holiday season coming up, I understand people want to get together, but there's responsible ways to do that. So be mindful of those CDC guidance. It's important that we do continue to be to take a lot of personal responsibility, and that's what it ultimately comes down to. Because this does impact not just the individuals that have it, but as hospitals do have staffing challenges, if somebody has a heart attack or a car wreck or whatever, that creates logistical challenges for that as well. So it does impact multiple areas. Item number 26 will be no action. Item number 27 is deliberate and consider possible action regarding security devices or audits. Don't have anything on that. Item 28 is deliberate and consider possible action regarding personnel matters. Do we need to approve the
Personnel change?
So move.
we have a motion by Commissioner Leon Clement to approve the personnel policy for administrative leave relating to COVID. Is that the correct way?
Yes.
And seconded by Commissioner Hollowell. Any further discussion? If not, all those in favor signify by saying aye. Aye. Any opposed? Ayes have it, motion passes 4-0. And just what that does is it does allow the elected officials and department heads, mainly going back to the elected officials, a little more discretion when it comes to COVID-related leave. Item number 29 is future agenda items. We have anything?
So we're bringing the PACE thing back.
Next thing will be on the, what day that was, 28th.
Yeah, okay.
Anything else?
No, can't think of anything else.
Not? We'll at least talk about it on the 14th, I'm assuming. If not before then, we can always,
We said it tentatively for the 14th.
I think we set it for the 14th as of now. Anything else? All right, item 30 is to adjourn. Have a motion by Commissioner Hollowell, second by Commissioner Snuggs. All those in favor signify by saying aye.
Aye.
Any opposed? Ayes have it, motion passes 4-0.